some of which are still going on, but that's okay. So I'm Jason Coleman. I'm the president of the Nashville chapter of the File Society. I want to thank y'all for coming out. I want to thank Josh for coming out. As many of you know, we tried to do this last summer, and we had to cancel the day of. There was a big storm in Houston where Josh was coming from, and so
everything was underwater. It was really bad.
His flight was supposed to get in at 9, which should have been, plenty of time. And I think by the time they rescheduled it, he was going to land at like 2.
The next day.
Oh, the next day. Okay, even more. So unfortunately, we couldn't make it work. But I'm glad that he was able to come this time, and that y'all were coming out. And I remember Steve in particular signed up twice, and imagine some of you other ones may have signed up again. Linda, you might have signed up twice. I don't remember. But like I said, I want to thank y'all for coming out. Josh Blackman is an associate professor of law at the South Texas College of Law in Houston. He specializes in constitutional law, Supreme Court, and intersection of law and technology. He's the author of a few books, Unprecedented: The Constitutional Challenge of Obamacare, and Unraveled: Obamacare, Religious Liberty, and Executive Power.
Coming out in September. Check your Amazon.
There we go. He's testified before Congress. He's an adjunct scholar at Cato. He was the founder of Fantasy SCOTUS, which for Supreme Court watchers is the challenge or the game where people try to predict the outcome in cases. And I don't think you predict individual justices' votes too.
Wasn't very good this year. Did not work well this year.
And so that way, he's a blogger at his website, joshblackman.com. He's the leads cutting edge of legal analytics as director of judicial research at Lex Predict. He's the founder and president of the Harlan Institute. So obviously he does lots of things. His blogs and op-eds are all over the internet. You don't have to do very much. You don't have to look very hard to find his work all over the place. And it's,
I come to you even.
Yeah,
to look there you go. I come to Nashville.
So with that, let's thank Josh for coming.
Thank you. Thank you so much, Jason. It's a pleasure to be back. The event I canceled here, I think, was the second event I've ever had to cancel, the first due to weather delays, so I'm very grateful for the opportunity. So we have a treat, my friends, today. You get not one constitutional right, you get 2 constitutional rights, right? We have to be very protective of all of them. So today our focus is on the First Amendment, the Second Amendment, and 3D printed guns. So before we get started, how many of you know what 3D printing is? I'm impressed. I've given this talk and maybe half the hands go up. So to give you a little bit of an overview for those maybe who aren't too familiar with it, the same way that I can design an object on a piece of paper, I can draw on a piece of paper, I can design an object on a computer. You can design something like a house or even a car or anything you wish. Now, I'm going to give you a little brief tutorial on how this works, and I promise this is actually relevant. So for those of you who remember from high school geometry, you have something called a cylinder, right? A cylinder is basically a stack of circles, one on top of the other. That's what a cylinder is. Now, if I want to tell you to draw a cylinder, I'd have to give you some information. First, what's the height of the cylinder? And second, what is the radius? That's, from the center of the circle to the edge in your high school geometry. So if I tell a computer, draw a cylinder with a height of 20 and a radius of 5, that's what pops out. You see, you use words the same way I'm describing to you. Height of 20 inches, radius of 5 inches. You use that to design it on a piece of paper or out of a ball of clay. The exact same principles apply to 3D printing. We should not lose sight of the fact that 3D printing is nothing more than explaining data in a graphical form using words and numbers. Why is this relevant? I'll give you a preview of later in the talk. That stuff's protected by the First Amendment. So let's move on a little bit. You can make all sorts of objects with a 3D printer, from little, silly trinkets to complicated balls. And what you use to make this is a device that looks like this. You can actually see a little race car being created there. It's a 3D printer. Give you another shot of what these sort of things look like. The principle of 3D printing is identical to making a candle. Okay, everyone's made a candle. You know the general process, right? Where you take the wick, you dip it in the wax, you lift it up, you let it cool. You dip in the wax, you lift it up, and let it cool. Maybe you dip it in a different color wax or different type of wax. You make different patterns, right? Each time you dip the wick in, it gets a little bit thicker around the base. 3D printing works in the exact same fashion. But instead of dipping something into plastic, which is not very accurate, it uses a little nozzle. Right here. See that little nozzle? And it sprays a very fine layer of plastic resin. And we're talking maybe a few millimeters in width. It's a very fine layer. And you layer one on top of the other. You spray a little bit, you spray a little bit, you spray a little bit. And each layer has a different width and height and color and properties. So the same way you make a candle, you use the 3D printer to keep raising the object up and making it taller and taller. So I want to show you a series of photographs that illustrate how the 3D printing process works. Whenever you realize what's being printed, I want you to raise your hand, okay? Because you'll know in a minute what's being printed. I'll give you a step-by-step. So we start here with this, looks like a pile of goo, right? You know, it looks like a little puddle. But when they start putting more of this green plastic on top of the other, you can see a pattern forming. This is like almost like a honeycomb, like a beehive a system. So you put a little bit more, put a little bit more, and these layers come down maybe every second or so. You keep going higher and higher and higher. You put them more, keep putting down more. And this is about 10% of the way through the process. Does anyone see what this is yet? Shout out if you see it. Close, very close. Okay, frog, bust, you're actually on the right track. Next one I click, you're gonna see it. Ready? Anyone see it?
That's a man's turtle. The gecko lizard.
Really close, you're really close. One more, one more. Brian Fitzpatrick, what is that? What is being 3D printed, Brian? Let's see. You're really close. Okay, one more. You'll see it now. Anyone? Ooh. Okay, you guys are disappointing me. Next one. Yoda. There it is, Yoda. Yoda, very good. Yoda from Star Wars. Someone said a lizard, a frog, a bust. You're on the right track, okay? So you can see, you can make, there it is. You can make very intricate designs, right? Extremely intricate designs using nothing but these very thin layers of plastic layered one on top of the other. And now you can see they close off the head. I mean, this is a sort of thing which, I mean, I have no artistic skills whatsoever. If you gave me a ball of clay, I wouldn't know what the heck to do with it. There's nothing I could do, but this I can do, right? I can design an object on a computer and, hey, click, print. And then if I put the right type of plastic in, within, you know, this object probably took a few minutes to print, not a very long time, probably far less than it would take me to sculpt anything. And you can make surprisingly intricate objects using a 3D printer. This is a series of interlocking gears. And if you actually spin this thing around, the gears spin with it. It's actually a very cool design. So of course, though, with this new technology, people can create frogs, they can create gears, they can create race cars. We're in America. What do people want to create? Guns. Thank you, Tennessee. Yes, they want to create guns. So one of the first major popular applications of 3D printing is something that people would want to make that maybe they perhaps shouldn't make, which I don't accept, but we'll start from that premise. So the very first person designed a 3D gun called it the Liberator, a very liberating name. This is actually the 3D blueprint of the barrel of the Liberator. And for those of you who know guns, it's basically a tube that the bullet goes through. That's what a barrel basically is. The inventor of this technology was this gentleman. His name is Cody Wilson. Cody was a first-year law student at UT in Austin. And about halfway through his first year in law school, he decided that law school wasn't for him and that he wanted to make a name for himself by designing a 3D printed gun. Now, I should disclose, I'm actually Cody's lawyer. Totally independent. The Tennessee Law Review held a symposium about 2 years ago on the Second Amendment, and they invited me to write an article. I went to Knoxville for my first time. And I wrote an article on the First and Second Amendment of 3D printed guns and why I thought regulations on those were unconstitutional. I wrote the article. Who the hell reads law review articles, right? Cody read my article. And he called me one day out of the blue. I mean, he sent me an email saying, Josh, you want to talk? I'm like, okay. He's like, Josh, I want to hire you. I'm like, what do you mean you want to hire me? I'm a law professor. He's like, I want to hire you to sue the government. I'm like, okay, I'm listening. So I'll get to his case later. But Brian will attest, unless anyone tells you scholarship is a waste of time, they're right. But in very few cases, it actually gets you a paid client, although this is more a labor of love than anything else. In any event, Cody designed several different gun parts. Oh, he's a self-avowed anarchist. His politics are interesting, but he's a good guy, and I'll get to the case later. But he's a good guy. So one of the first things that Cody designs, does anyone know what this is? Someone should know. It's an AR-15 lower receiver. So for those of you who pay any attention to the news, the AR-15 is the most awful gun ever created. It's a weapon of war. What people don't actually realize is that the thing that makes the gun work, the guts of the gun, is this thing. It's called AR-15 lower receiver. And this is the actual thing that the federal government regulates. But you're allowed to make your own AR-15 lower receiver. You can take it out of metal, you can mill it. That's kind of hard. Cody invented a way to 3D print the receiver for an AR-15, which you can slot in. And here you can see how he basically literally put into an AR, and it works just fine. Another item that Cody 3D printed is this white magazine. He called it the Cuomo. Does anyone want to guess why he called it the Cuomo? After the governor of New York, who banned AR-15 magazines with what, more than 10 or 15 rounds or whatever happened to be. So basically, Cody got into the business of building stuff that people want banned. So the best thing was he made a silencer for an AR-15, I'm sorry, for a Glock, called the Dirty Diane. Who do you think it was named after? I won't answer. But he has funny names for a lot of his products. But the thing that put Cody on the map was not these sort of accessories, right? What put Cody on the map was this. What the heck is this, right? What are we looking at? It's like a little squiggle, little blue thing. These are the parts for a fully functional pistol, which he called the Liberator. I know this doesn't look like anything, but that's actually the handle. That's the barrel. That's the trigger. These are the various coils used to create the tension. That's a bullet right there. That's the muzzle, and that's the little nail which can be used for a firing pin. Right? Those are all. I mean, if you think about it, those are all the parts you need to make a gun. And he found a way to 3D print the entire thing, with the exception of the nail. He couldn't figure that you need to actually go to a hardware store and buy. But everything else is 3D printed. This is what the Liberator looks like assembled. If you notice, there's like a piece of rope there. The first few dozen times testing it, Cody didn't pull the trigger by himself. As you can imagine, that can be very dangerous because it can blow up and destroy your hand. So what he would actually do is tie a rope to the trigger and take about 15 paces, right? And yank it. And a bunch of them did blow up, which was probably good. But after a while, Cody was able to figure out the process of making it strong enough to withstand the combustion. I mean, when you fire a gun, it's an explosion, right? And plastic is generally not meant to handle an explosion. So he has this very lengthy process, which he explained in an exhibit in our case, about how you have to treat the barrel with acetone, and you have to give it a vinegar bath, and you have to treat it and cure it, and it's an entire process of making the plastic strong enough. So contrary to what the government will have you believe, this isn't as simple as clicking print and having a gun. There's actually a lot of work that's going to make this into a functional gun. But number one rule, don't ever point a gun at someone. Cody didn't follow that rule. That was his apartment in Austin, where he basically made this. Now, this is Cody. This was back in 2013, right? This is when he absolutely. I'm sorry. This was back in the winter of basically December of 2012. 2012. So almost 4 years ago. So is there a problem? Right? We're lawyers here. Did Cody break the law? Did Cody do anything illegal? Okay. So the first misconception that I want to disabuse you all of is that this is not how 3D printing a gun works, right? It's not the case that you click print, poof, and a gun comes out. That's not how this works. I've explained to you there's a very lengthy process. Another thing that I want to explain to you is that Cody did not invent making guns at home. So how many of you know what a zip gun is? See, I love coming to the South. People know what these things are. I gave this talk in New York, not a single hand went up. What the hell is a zip gun? It's like a little zipper on your pants and your flop. What's a zip gun? And by the way, when I explained that you can make a gun at home, they were petrified. Going, oh my God, people can make their own guns at home. They were petrified. Okay. This is a gun. Okay. This is a soldering gun combined with a nozzle and a hose. I can go to the hardware store, buy, I don't know what, $10 worth of parts. I can make a fully functional gun. There's a little spring, a little soldering iron, and a garden hose nozzle. Okay. It's not hard to make a gun. I actually tried Googling of how different people make zip guns. This is one of those little keychain flashlights you can buy in the store. You can make that into a gun also if you get enough power. This video, which I'm going to show you in a second, do not try at home. People can probably guess what's about to happen. These idiots, and I'll tell you why they're idiots in a second. I'm not being mean, they're idiots. These idiots manufactured a rifle out of a piece of rubber tubing, a metal pipe, and a single shotgun shell. Okay. At the end of the at the end of the metal pipe, there's this little dimple, which they use as a firing pin to ignite the charge in the shotgun shell. Okay. So again, do not try this at home. So these people, these guys in their garage, load up a shotgun shell into this tube. Now, you can see the the tube's there, the cartridge in there. Now, let's pay very close attention to the situation. What's going on here? They're firing at a box, right? And you can see that there are several holes in the box, which means they've done it before. Does anyone see anything problematic about this firing range other than the fact that they're inside? Does anyone see a problem on this picture? Bingo. So there are electrical wires here. They're firing at live wires. Even worse, they're firing at live wires connected to a fan, which I suspect was on. So again, do not try this at home. Okay, so what they're going to do is they're going to jam the pipe into the back of the shotgun shell. What happens? Boom. Boom, right? They're literally firing a shotgun shell at wires in a garage. These guys are idiots. Okay, fair. But they made a gun with about, I don't know, $2 worth of parts from Home Depot. Right? This is not very difficult. We're talking about a rubber pipe and a shotgun shell, which you can make a fully functional one-shot gun. The Liberator was a one-shot pistol. It was not very effective. It fired like, I think a 22 or some very small round. I mean, the bullet you saw was not particularly large. So what do we have here? You make a gun very cheaply. Now, did these guys break the law, right? They made a gun in their own home. According to our good friends at the Bureau of Alcohol, Tobacco, and Firearms, our favorite convenience store, right? Did they break the law? No. As long as you make a gun for yourself, that's not being sold in commerce, making the gun for yourself, you're fine. Now, a couple states have actually imposed laws, for example, California, that every gun must have a serial number on it, even guns you make at home. If you try to register a homemade gun, they'll say, I'm sorry, we can't register it. It's not on our approved list of guns you can register. So some states have actually made it illegal to manufacture guns at home. I'm not too hopeful about that litigation being successful. It's California. But under federal law, at least in other states, it's perfectly lawful. Okay? So why did Cody hire me, right? If he's doing things that are perfectly lawful, why on earth did he hire me? So the problem with Cody wasn't the fact that he made this Liberator for himself. The problem for Cody was that he put these Liberator plans, files, on the internet. And the State Department sent him a letter out of the blue saying, Mr. Wilson, we noticed that you put these files on the internet. We think that you may be in violation of arms export control laws. That by putting a file on the internet, you are violating arms control laws as if you had sent a Stinger missile to Afghanistan in 1981. Right? This is where these laws came from. So these were Cold War era statutes. Please remove immediately from the internet your files. Love, John Kerry. Right? Or I think he'll still Kerry at the time, yeah. So that's why I'm his attorney. Okay, so I'll get more there later. But we need to build a foundation, right? Let's talk a little bit about the First Amendment, right? Freedom of speech. The cornerstone, right? The very basis of our free speech case law is that the government cannot restrict speech based on its content. So-called content-based restrictions are subject to what's known as strict scrutiny. This is the highest level of scrutiny that the court employs. And justices of all stripes, liberal and conservative, have said, when the government starts picking and choosing which speech to censor, that's where the judiciary intervenes. Because the government can't pick which ideas we're exposed to. That is the essence of censorship. But Josh, wait a minute, Josh. We're not talking here about, pornography or obscenity, or some sort of non-obscene obscenity. We're not talking about, the Communist Manifesto, right? We're talking about files that can be used to print guns, which can kill people. And guns are bad. And then, we need to have gun control. And we need to stop, gun violence and whatever else people say, right? So the response to this is, so what? The mere fact that speech can be used to hurt someone else does not render it unprotected. To give you a very easy example, which many of you may be familiar with, is the Anarchist Cookbook. Everyone know what this book is, right? This was a book published, 50s, 60s, 70s, that was basically how to be a terrorist, right? It's titled aptly. It described in very specific details how you can make bombs out of chemicals you can buy at the grocery store, right? How to make different incendiary devices using basic chemicals you can buy through mail order. This book gives you the instructions of how to be a terrorist, how to blow stuff up. The government's tried so hard to ban these books from the shelves, and every time they tried, the court said, no, you can't do this. You can't restrict a book because it can be used to harm someone else. This is pretty black letter law. It's been like this for decades. The court held the only sorts of speech you can restrict are those where there's an imminent threat of violence. The key word there is imminent, right? The classic case is called Brandenburg versus Ohio. You may recall there was this Ku Klux Klan leader. And he was giving a rally, a KKK rally, saying, we're going to go march on Washington the 4th of July, which was about a couple weeks after. We're going to march on Washington. We're going to go down to Mississippi. We're going to go down to Florida. We're going to tell all these people we think about the civil rights movement, whatever. And they arrested the guy. They arrested him for his speech. And the court reversed his conviction. They said, wait a minute. He was saying, hey, let's do something, next month, right? That is not enough. Merely putting speech on the internet or publishing a book does not give the government a license to censor it on the basis of its content. Now, I'm saying, wait a minute, Josh, we're not talking about a book here, right? We're not talking about a speech, right? We're talking about code. We're talking about, ones and zeros and, all these, technical things which justices don't really understand. Well, they actually do have a pretty good sense of this. And the court has held, in a number of cases in the last decade or so, that the mere fact that you articulate an idea on a computer does not deprive it of its First Amendment protections. This was a case from 2011, about 5 years ago, from Justice Kennedy, called Sorrell v. IMS Health. And the court held, and I highlight the passage, The creation and dissemination of information are speech. The mere fact that you choose to express yourself in code rather than in words does not deprive it of Second Amendment protection. This is why at the outset I showed you the code to make a cylinder. Now it makes sense, right? The same way I described to you make a cylinder with a radius of 5 and a height of 20, I can say make a barrel with a radius of 5 and a length of 20. Yeah. You're using ideas in a computer fashion. The First Amendment still provides protection. Okay? So that's the First Amendment angle of this. I promise you 2 amendments. We'll get to the second one now. The Second Amendment, and in Tennessee, I don't need to repeat it, but in New York I would, says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. So for the first 200 years of the Supreme Court's run, the Second Amendment didn't have much weight until the case in 2008 of District of Columbia versus Heller. This is Dick Heller. He was a security guard who lived in Washington, D.C. His job, ironically enough, was to defend federal judges. And as part of his job, he was given a gun to guard members of the federal judiciary during the day. Alas, after his shift was over and he had to go home for the day, he had to surrender his gun. And he lived in a pretty rough part of town. And he had no way of defending himself. So I guess we can trust him to defend the lives of judges with guns, but when he's on his own, too bad. So a lawsuit was filed. Actually, the lead attorney was Alan Gura. Alan Gura is actually my co-counsel with Cody. Get to that in a second. And they challenged the District of Columbia's handgun regulation. And in a 5-4 decision by Mr. Bryan's old boss, one of the better decisions he's had, in District of Columbia v. Heller, the court invalidated the District DC's handgun law. And they said that the Second Amendment protects an individual right to keep and bear arms, separate and apart from malicious service. Okay, so that was in 2008. 2 years later, there was a second challenge brought to the court. This one from the city of Chicago. At the time, the city of Chicago was the only place in the country other than DC that banned handguns. Not just like, license or background check, banned. You can't have a handgun in city limits. Have the highest homicide rate in the nation, but we'll put that aside for a moment. The plaintiff in this case was Otis McDonald. He wanted a gun to defend himself and his family. He challenged the law in court. And I love this picture. It's actually Dick Heller shaking hands with Otis McDonald. And he won. In 2010, the court held that the Second Amendment is incorporated or extended to the states, that the states cannot have a flat-out prohibition on the right to bear arms. I always like to pause for a minute. Mr. McDonald died about a year ago, and he was a very good man, and he fought for civil rights in a way that most people don't understand. So I try to remember whenever I get to this point, but he was a really good guy. I met him at the arguments in this case, and he's not who you think of when you think about vindicating the Second Amendment, right? He lived in a rough part of Chicago where literally people were shooting down the block from him, and he wanted a way to defend himself. So he did good for the Second Amendment. But that was the last time the Supreme Court really addressed the Second Amendment. I mean, we're now, 2016? The court has not granted certiorari in a single Second Amendment case since then. I'll pause for a moment. There have been a couple dissents by Justice Scalia and then now Justice Thomas saying, hey, we have this Heller thing, right? You guys keep denying certiorari, what gives? So there was a case from San Francisco. This was an egregious case where the city basically required you to keep your gun at home in a locked box. Your gun, you can have it, but you can either carry it on your person at all times, but if it's not on your person, you have to keep it in a locked box. You can't keep it on your nightstand or in a drawer. It has to be in a locked box. There was this great exchange when Heller was argued back in 2008, where DC had a law saying you need to keep your gun disabled with these locks, right? We have to basically take the gun apart, have a lock go through it. And I think it was Scalia asked Walter Dellinger, have you tried unlocking one of those at night when the light's out without your glasses? Because he was saying, wow, piece of cake, just take the lock off. And Scalia was like, What if it's at night and you have your glasses on? Can you take that lock off? Anyway, so Scalia and Thomas have dissent in a number of these cases, but for the most part, the court has not touched the Second Amendment. They simply haven't readdressed it. And now, with the changed composition of the court, I don't expect them to either, because the lower courts are doing their own thing. But I want to do a little development here and analyze this Second Amendment right and try and articulate aspects of it. And the first one sounds controversial, but it really isn't, is that you have a right to acquire arms. Now you're saying, wait a minute, Josh, are you saying that there can be no laws restricting the sale of guns? No, I'm not saying that at all. But what I'm making the proposition is, if we have the right to bear arms, we have to get them from somewhere. Right? If we have the right to bear arms, we need to get them from somewhere. Usually that means you go to a gun store and you buy it. That's how the rights existed for 2 centuries. To give you an example, Dick Heller, I love this picture. This is how you keep your guns. Back with some little stupid locks on them, right? He'd actually had a gun from the 1970s before the gun ban went into effect. So he could keep his gun. He had to keep it locked up at all times, right? It has to be literally locked up with this double, a trigger lock and a barrel lock. I mean, this is absolutely insane, but this is what would have to happen. After Heller, he went to the City Hall in D.C. and he got his permit. You could see him smiling with this permit. This allowed to buy another gun. At the time, I think there was one a federal firearm license, FFL, in D.C., but he managed to find him, and he got another gun. The import of the right to bear arms means you have to be able to get a gun from somewhere. I want to drill down further. And this one is actually, I think, on much stronger grounds. I think there's not only a right to acquire arms, I think there's also a right to make arms. And I think this right is far more deeply rooted. If you think back to the time of the American Revolution, right, there was no Cabela's. There was no Walmart. There was no Dick's. If you wanted a gun, you made it, right? There was no mass manufacturing. There's no Remington. There was no Smith & Wesson. There's no Colt. You made your own gun. And if anyone's ever seen the John Adams miniseries, there's this great scene I love where they have Abigail Adams pouring lead to make musket balls for the colonial troops. So here I'm on strong footing. We have a very long and distinguished tradition in this country of making arms for your own self-defense. So you have a right to acquire arms, right? You have the right to make arms. This, I think, bolsters Cody's case a bit about it's not only about having a gun, but actually making one for yourself, okay? But I'm not done yet. We have here an interesting scenario. We have 2 constitutional rights working together. So let me give you an example, right? Let's say the government passes a law that says if you're a city employee or state employee, you can't wish someone a Merry Christmas. Well, maybe not so implausible, right? But illegally, you cannot wish someone a Merry Christmas. Would that law be constitutional, right? So there's 2 things you have to think about. There's a freedom of speech. You're basically restricting a government employee's speech. Also free exercise, right? You're basically saying you can't wish someone a Merry Christmas. Now, whether a law be upheld or not, different question. But there are 2 distinct inquiries that you'd have to think about. The court has addressed this, what they call these sort of hybrid rights. Another opinion by my friend Justice Scalia, which was employment division against Smith. When you have these 2 rights work in conjunction, free exercise and free speech, they sort of bolster and become heightened review. Well, what do we have here, my friends? Cody's talking about the Second Amendment. You are literally talking about how to make a gun. And to the extent that there's free speech involved, I think it's even more scrutiny because the subject, the content of the speech, is a second constitutional right. When I give this shtick in college campuses, I would say, what happens if the government said, you can't publish any books about how to perform abortions? Oh, all the hands go up, right? Same, right? This one's enumerated constitutional right, but the idea is the same. You're stopping someone from speaking about a constitutional liberty. Now, are there laws against what Cody did? The answer is no. So there's one federal statute called the Undetectable Firearms Act that was passed in 1988, and it basically says that you are required to have a gun. In any firearm, you're required to have a certain amount of metal, enough metal to set off the magnetometer, the X-ray machine, at the airport. Right? It's a certain quantity of metal. that's why if you go through the machine, like chains won't do it, but keys will. So you have a certain quantity of metal that will trigger this. This law was actually a product of the Glock handgun. And really, it's Bruce Willis's fault. So for any of you who remember the movie Die Hard, Bruce Willis played the John McClane character. This guy who basically saves the world, right? Was the greatest Christmas movie ever, Die Hard. There's this one line in one of the Die Hard movies where Bruce Willis goes, and I apologize, I'm going to butcher it, but I don't have his swag. He says, "Luggage, that punk pulled a Glock 7 on me. You know what that is? It's a porcelain gun made in Germany. It doesn't show up on your airport X-ray machines, and it costs more than what you make in a month." Every single thing he said was false. Every word in that sentence was wrong, okay? There is no Glock 7. There's no such gun, right? It's not made of porcelain. It's made of metal with some plastic fibers. It's made in Austria, not in Germany. It will show up on an X-ray machine, and they're actually quite affordable. So virtually everything he said was wrong. But still freak people out that they'll have these plastic guns, and they'll get in airplanes, and they'll commit acts of terrorism, so they pass this law. So how did Cody get around this? Well, in the Liberator blueprint, there's a slot where you're required to solder in a piece of metal, a metal block. So if you make the gun as designed, there's metal in it, the Liberator is fine. So the design of the gun, at least, comports with this act. Now, we don't have any ban on federal firearms, although some politicians, Senator Schumer and others, this was actually one of the highlights of Cody's life when you make one of Senator Schumer's charts, right? When Schumer's pointing at something that you did, this is like, life goals. So Senator Schumer tried to extend the Undetectable Firearms Act to all plastic guns. That bill went absolutely nowhere. Some other people suggested, well, this technology is so dangerous, we need to ban the materials used to print 3D guns. We need to ban plastic, right? Well, I got a surprise for you folks. You can print with you can 3D print plastic, or you can 3D print metal. You basically grind up aluminum and you make it into a powder. This is a fully functional 1911 handgun made entirely in a 3D printer. I held it in my hands. I mean, it feels real. It's got the weight, got the balance, everything's in there. So you make a fully functional 1911 handgun out of 3D printers. Now, this costs almost $40,000 to make, an entire week of labor. You can buy this in a store for a couple $100, whatever. So probably not not the best not the best way of using your money. So banning plastics will not cut it. One professor said, well, then we need to ban gunpowder so people can't make their own guns. Yeah, no, that's not going to work. The more likely route with which 3D guns were regulated is actually involving IP. See, you thought this was going to be a common lecture, getting IP also, okay? Intellectual property. So does everyone know what DRM is? Digital Rights Management. So you may recall in the olden days, if you bought a song on iTunes, the iTunes store, you couldn't play it on a Microsoft MP3 player. Or if you buy a book on an Amazon Kindle, you can't read it on a Barnes & Noble Nook. This is what's called DRM. Files on your computer are locked down to be read only by a certain format. The DRM was used to prevent people from stealing music. You even have books with this DRM technology. I'll give you a creepy story. So if you had bought the book 1984, George Orwell classic on Amazon Kindle, Amazon Kindle is a device, download books. One day you wake up and you realize, oh, wait a minute, 1984 is not my Kindle anymore. What happened? Amazon had a dispute with the publisher of 1984. So what did they do? They remotely deleted the book off your device. Creepy, huh? Full books. They remotely removed 1984 from your device. You had it one day, gone the next. You don't actually own Amazon Kindle books. You have a license to it. Same for music you download or movies you download. It's a license and it's revocable. I'm sorry, it's revocable, not irrevocable. It's revocable. But the biggest threat, right? The biggest threat with DRM is 3D printing. Because if you download a song, it's not a big deal, right? If you download a movie, okay, whatever. But what if you download the blueprints for the next Michael Jordan sneakers, and you can print Air Jordans in your, garage? So instead of spending $250 on a pair of sneakers, you buy a couple dollars of plastic. The real threat to 3D printing is stuff, right? Actually printing stuff. And if I can give you an economics lecture, I went to George Mason for law school. This may be what we call a bootlegger and Baptist coalitions. Anyone know what these things are? Other than Brian? Yeah.
Well, the bootleggers and the Baptists inspired me that prohibition.
Exactly right. So during Prohibition, right, who are the two groups that wanted it? So on the one hand, you have the Baptists, right, holding up the Bible, the good word says alcohol is sin. Who else wants Prohibition? The bootleggers. Why? Because they'll make a killing. In fact, are there dry counties in Tennessee? On the border of the dry county, is there a liquor store on the other side of the county line? That liquor store is the reason why the dry counties remain, because they have monopoly rents, right? They basically get all the business from these poor people with no alcohol to cross a border, a mile away to get liquor. Same in Texas, right? On the county line with the dry county, there's a liquor store right there. Same thing with fireworks, right? In Pennsylvania, New York border, Pennsylvania, Maryland border, there are fireworks stores in every single border. So the same deals apply. There's a Baptist and there's a bootlegger coalition, right? So first off, who is the bootlegger here? Of course, it's Kanye West, right? So you guys are in a retreat. So on an episode of the Kardashian show, he actually said, "I'm afraid of 3D printers. The internet destroyed music. This is what we're afraid of in textiles." He makes very expensive clothes, sneakers and apparel. They're afraid that these devices will be used to rip off all their stuff. So here's where the Baptists and bootleggers get married. Who are the Baptists? Well, the gun control people, right? They want to ban guns. Kanye West doesn't really care about guns. He wants to get rid of 3D printing. So what happens if you could put a filter inside your 3D printer? The same way there's a filter on your Kindle or a filter on your iPod that says you can only listen to certain files. What happens if you try to print a gun and it said beep, beep, beep? No. And what if, of course, the government administers that filter? Or a private consortium of groups administer the filter? Has anyone ever tried to take a photocopy of a currency, of a $100 bill with a very high quality Canon machine? Anyone ever try that? What happens?
It doesn't work. I haven't tried it.
It doesn't work. We'll actually spit out an error message. The Treasury Department's actually worked with Xerox and Canon, say don't make copies of things with these signatures, these special watermarks. So a similar regime could be installed to 3D printer saying, you can't print this. But it's not, currency, which is a very specific item. It would be a range of items that might look a certain way. Is that a gun or is that a flute? I don't know. Ban it. Right? A barrel of a gun, a flute look a heck of a lot alike. So this is, I think, is probably the way they'll try and hit it, but who knows? In my remaining time, I want to talk about export control laws, because this is actually how they got Cody, how we got in trouble. So has anyone ever worked with ITAR? What's ITAR?
Interstate Transportation Racketeering. Right?
Oh, wrong ITAR. No, there's so many damn acronyms. The International Traffic in Arms Regulation. Close up. This was a series of regulations created during the Cold War to prevent American firms from shipping weapons, arms, if you will, to the Soviets. I mean, this is why this law was created. It's a fairly thick guide, and it's a very arcane area of law, which I've had to learn more about than I ever wanted to. But the bottom line is that the government has taken the position that exporting is no different than uploading. Publishing information is an export. So, for example, what if you want to publish a book on cryptography? Do you need the government's permission to send this book to Cambridge or Oxford in England? The answer is maybe. The government has taken very shifting positions on this question. And at various times, they've suggested that if you actually want to send cryptography books abroad, you may need the government's permission. They've not really enforced this, maybe once or twice. But the first time that they actually clearly enforced this, without a doubt, was in this May 2013 letter sent to Cody, my client. And it says, Mr. Wilson, we noticed you put these files online, right? And here, look, you put these items on the internet. Okay. Now, You can't put a pistol on the internet, right? You can't jam a gun into your router. You can't jam I told you, the dirty Diane silencer into your USB port, right? Well, it's actually put in the internet where the files. But the government said that these are technical data, and these files are subject to our jurisdiction. And the key word here, and I put it underlined in red, is that such data should be removed from public access immediately. Immediately. This is a prior restraint of speech. The government's telling someone, don't put this available online. Take it down. Remove these files. This isn't classified information. These are publicly available open source handguns designed for the public. Files that you can find in a million places on the internet. And by the way, Cody's file, if you Google for 3 seconds, you'll find it. He took it down, but you'll find these files all over the web. That was actually the first question when Cody called to hire me. I was like, Cody, did you take the files down afterwards? He's like, yeah. Okay, good. I wanted to it's a lot easier to challenge something on his face than if they're trying to prosecute you. That's my first question. I was like, did you actually listen? Like, yeah, we did. Okay, good. It's a lot harder to do the other way. So we actually challenged this in federal court just about a year ago. The district court denied our injunction, denied our preliminary injunction. We had arguments in the Fifth Circuit in June. I thought they went fairly well, and hopefully have a decision. But even the judges in the Fifth Circuit panel seemed to appreciate how dangerous this is. And one of the judges asked, well, what happens if instead of putting this file on the internet, Cody put in a book in the library? Cody published a book in the library with the same information, right? It'd be a big book, a lot of pages, but he put the same information in a book in the library. And the government lawyer kind of hemmed and hawed, and he said, well, that'd be different. And the judge asked, well, why? Why is it different to use the internet or a book in the library? This is the banned book example. The number one rule of being a government lawyer is do not say you're banning a book. So you may recall the Citizens United case argued a couple of years ago. It was argued twice. And the first time it was argued, Malcolm Stewart, who's a very good lawyer, has been at the SG forever. I think it was Justice Alito asked, the case involves banning a movie by Hillary Clinton, right? And the government says you can't put this movie out within whatever 30 days before the election. So Justice Alito asked Malcolm Stewart, what if it was a book instead of a movie? Could you guys regulate that book? And he tried to, dance and bob and weave, but eventually he said, well, yes, Your Honor, we could regulate that book. And Alito's like, what? I mean, he knew the answer, but he wanted to make it clear for Justice Kennedy what the heck the deal was. So when the case was re-argued the following fall, Elena Kagan was then the Solicitor General, and Alito asked her again, so about this book banning, she's like, yeah, no, we've changed our position on that. No more book banning. So the number one rule of being a government lawyer is you cannot ban books. So once the judges in the panel are asking about library and books, I'm like, okay, I may get my fees after all. 1983 is a beautiful thing. So hopefully we'll have a decision on the merits. We don't have one yet, but I mean, my counsel, we're really committed to this case. It really started off as an academic exercise in Tennessee, in the Tennessee Law Review, but it's now basically sitting in the doorsteps of certiorari if it goes otherwise. So I'll stop here and welcome your questions. Thank you all so much.
What's the case style of the one?
It's called Defense Distributed versus U.S. Department of State. And if you go to my blog, I have a link with all the pleadings. Go to joshblackman.com, and I have all the pleadings linked. Yes, sir.
Is there any constitutional block to a DRM regulation either? I mean, obviously not for private consortium, but there's government involvement.
So there was a case called Eldridge versus Ashcroft. Was that your? Yeah. So that was the case Lawrence Lessig argued. He basically tried to argue that various restrictions on IP violate the First Amendment. And it was an RBG opinion, I think. Anyway, whoever wrote it, I'm trying to remember the details, but the court basically said, and I'm summarizing, you can't use a First Amendment to attack IP laws, right? So, for example, if Cody had put on the internet the 3D gun files for a Glock 19, right? Glock could have sent him a takedown notice, and he'd be in violation of their IP. What makes this case unique is he put on the internet open source files that he created for the world to share. I mean, that's actually a core element of Cody's philosophy is sharing information globally. I mean, that's why this regime makes the government so nervous. But I don't think a straight up, if a private consortium of groups wanted to restrict, like if Xerox and HP said we're going to restrict our printers and there's no state action there, I don't think there's a problem.
Yeah, the government's involved.
Well, if the government says you have to install these filters, that's a different story. I think the currency example I gave, I think Xerox and Canon and HP have voluntarily complied. I don't think there's a mandate saying you have to put this filter in. If there is such a regulation, I don't think it'd be constitutional.
Voluntary.
I think it's all voluntary. Yeah, but what's interesting is a bunch of these companies have tried to stop selling Cody equipment, which is stupid because Cody went on Twitter and said, "Hey, if anyone buys and sells me, I'll pay you double." So I mean, it doesn't work. You can't stop information, which I think is another point that Cody's files are available in so many places. The idea of trying to use filtering to eliminate one source, there's no narrow tailoring, right? It's such a over-inclusiveness, under-inclusiveness, it's got everything. Yes, sir.
What's the, you go around and doing presentations like this, what's the biggest pushback?
Okay, so the biggest pushback is, what about printing nuclear bombs? What about printing ICBMs? What about printing machine guns, right? Was that your question?
No, just the entire idea of printing a nuclear bomb is, I mean.
Well, you should get Stinger missiles. I get that one a lot. Stinger missiles. Biological warfare. I get that one a lot also. So my general response to that is, so first of all, this is an as-applied challenge, but that's not a good answer for a crowd, right? The court has held that classified information is a different boat. The First Amendment does not apply to classified information. So if you're actually printing the blueprints for a classified F-16 missile or like a classified nuclear bomb, the government has other means of stopping you. But my response further is, we have a Second Amendment right, and the Second Amendment right affected handguns, pistols, the quintessential weapon of arms, which is what we have here. We're not requesting a right to 3D print machine guns. In fact, we wouldn't be arguing that. In fact, every Second Amendment case, the question is, what are machine guns? What are machine guns? Well, we're not saying machine guns. Cody's trying to print an arm that's perfectly lawful under Heller, and we don't need to go any further than that. The government can't erect this entire regime of censoring countless protected speech because it may go after some other speech that's not there. I'm reminded of Justice Breyer's opinion in the abortion case, the Whole Woman's Health decision. If you haven't read, you should. There's this one sentence where it says, well, maybe these various abortion laws may deter, law breaking, right? Like unsanitary conditions. But Breyer says, if someone is going to evade the law, these laws won't stop them. I want that printed on a hat and put into every single Second Amendment debate. If someone's gonna break the laws, what's the point of having the law? They're gonna break them anyway. So my general argument is with First and Second Amendment, you gotta be really narrowly tailored, and this does not cut it. Brian?
Well, the strongest government interest that I see here is almost a consumer product safety interest. These things are very dangerous. I mean, put them on your computer or on your printer, you simply explode things. And I mean, the same way the government doesn't let you sell a dangerous toaster, maybe the government shouldn't let you tell other people how to make dangerous toasters.
Oh, see, you shifted though. Difference between selling it and thinking about how to make it. See, that's the shift.
If the activity is lawfully prohibited, then isn't a manual on how to do the illegal activity also prohibitable?
Okay, so there are two responses. So first, it's not, as the idiots in the garage showed, it's not unlawful to make your own gun which can blow up in your hand. That's actually lawful. You're an idiot. But assuming that Congress banned the possession of these handguns, could they ban a book instructing you how to make it? There was a book published a number of years ago. It was called Hitman. Ever know this book? How to be a Hitman? Being a hitman is illegal, but a book of how to do it is not.
I'm surprised you say that.
Oh.
Because I remember when I was going to do a clerkship interview with Judge Ludick, Fourth Circuit had just issued an opinion, I thought, involving that book or a very similar book, where they held it was okay to criminalize.
I'll double check that, but
the Fourth Circuit.
That was the old Fourth Circuit.
I thought the proposition was if it's illegal activity, the government can stop you from telling people how to commit illegal activity.
Well, there was the Holder versus HLP decision, right? This was a decision a couple of years ago about lawyers assisting foreign terrorist groups. And the court held that that could be criminalized, but that to be actually an intent that you're trying to actually help people break the law, right? So I think if the government proves like with Hillary Clinton, proves intent, then that's something they can do. But merely publishing the book as an informational thing cannot. So wasn't Hitman published as like a novel form? Right. I'll check this afterward. But because we do cite Holder v. HLP in our briefs for the proposition that you have to have the actual intent. Now, if Cody put these files in the intent to assist foreign nations with committing terrorist acts, that'd be a different story.
Let me go back to the first part, though. Do you think the government could prohibit these unsafe guns because they could explode in your hands? Would that be consistent with the Second Amendment, that government interest?
Prohibiting guns you make yourself?
Because they're so unsafe, they could kill you when you try to pull the trigger. Not kill the person you're trying to shoot, but you, because they're like the faulty toasters.
I'll think about it.
Add to Brian's example of that, you've got a history. 10 people have made this, 5 of them have blown their hands on.
Mm-hmm.
So you have a track record that if you make it according to instructions, you got a 50% chance you can blow your hand
Yeah, I think the problem there is one of administrability, because how do you administer a law that people make stuff in their bathrooms?
What if the law is then the only people who can make guns are, you give a government license to, the big gun manufacturers, and it's a fairly permissive scheme, because they don't want to limit it.
Yeah, see, that's why I think there is a right to make your own arms within the Second Amendment. I mean, you could take another analogy. There's a track record of people getting their hands cut off by printing presses, right? And they're dangerous tools, and the government decides we only have people, in a certain license are able to have access to printing presses. Now, I granted a gun's more dangerous than a printing press, but I think there would be some scrutiny there, whether it's actually a state interest or this is a means to obstruct the right to bear arms. I think that's how the analysis would shake out.
And I'm not sure that there is, right? Would be a way to say you can't make your own dangerous toaster. Sort of struggling that they have.
Yeah, it's like a Cass Sunstein nudge type thing. Right? You can't hurt yourself. Yeah, yes, sir.
Well, the normal way our society deals with that is an eager plaintiff's lawyer sues Cody for the defective design.
Are you volunteering as a plaintiff lawyer?
No, I'm a nice guy.
Oh, you're a nice guy. Okay, I see. Yeah, I mean, there's a tort system, but Brian's question is assuming if Congress wanted to preempt the tort system by just regulating it. I think the answer is there will be scrutiny there, and actually, is this actually about safety, or is this legitimately trying to stop people from getting guns for self-defense? I mean, there's an issue you can think about. I mean, you don't think about this, but if you have a disability, right? You say you have a disability, you don't have a thumb. Okay. How you fire a trigger? I'm sorry, you don't have a trigger finger. How do you fire a gun? Well, you can rig it that your thumb pulls it. So there's actually a market of people making their own arms to fit disabilities, right? Triggering with a thumb instead of the trigger finger. Someone who maybe doesn't have a hand can pull it with their elbow. I mean, there are different ways of defending yourself. I'll try someone else to ask a question. Yes, ma'am.
Yeah, so I was just curious how courts have treated, if they have treated it at all, like web-based instructions for building explosives. So you wouldn't have a Second Amendment interest
So
here.
I'll give you an example.
Arguably have a First
So
Amendment.
after the Oklahoma City bombing, if you remember, that was they basically made an explosive, what was it, nitrogen and fertilizer and whatever else he found. I think it was Biden, but someone in the Senate, I'm like 90% sure it was Biden, asked DOJ, can we ban putting stuff on the internet of how to make bombs out of nitrogen? And DOJ said to Biden, no, we can't, right? Again, it's information, and the government doesn't have the power to start censoring information on the internet merely because it's information. And this is the hitman question, but I don't think merely putting information on the web or in a book form allows the government to censor it merely because it can be used to do harm. Yes, sir.
Two things. The first one is that I see a distinguishing characteristic between Hitman book and information on making arms. The first one is that when you look at a Hitman book, it serves only one purpose, and that is to commit a crime. That information is universally criminalized throughout the United States. I don't know of any jurisdiction that says it's all right to kill somebody for money. The manufacture of arms, however, is not a universally criminal activity.
Only in California.
Yeah. Well, no, even in California, you do have lawful arms manufactured. But I guess the second issue is that, as I listen to this, it seems to me that the thrust of the government's argument seems to be a restriction on speech to individuals outside the borders of the United States. The issue is that we don't want you speaking to these, ignorant foreigners who can't make zip guns. Or something along those lines.
Enlightened, not ignorant, they would say.
Yeah, well, yeah. But the idea being that we're not trying to restrict your speech within the bounds of the United States. You can print any book you want to, you can disseminate these, as long as the medium of dissemination restricts it to these fundamental borders.
So actually you raise a very good point about the ITAR. It's at bottom about preventing the speech from leaving the borders of the United States, but it's actually not. It's about non-U.S. persons. So the judge, one of the judges in the panel asked a question, and she said, well, what happens if you put this book in the library? She's from Houston. Put this book in the library. And what happens if an immigrant walks into the library and sees it? He's not a U.S. person. He's visiting from abroad. Aliens can walk into libraries. Now what? So the government's taken this not only to mean exporting, literally sending it abroad, but putting a file in a public forum, right? Occasionally when I give this lecture at the Troll College, students say, are there any foreign students in here? Okay, you have to leave now. Because I showed the barrel of the Liberator. I just committed an export crime. I'm not joking you. If I want to read the law as the government does, I showed you that picture of the barrel. If there was a non-U.S. person in this room, I just committed a felony. That's how insane it is. It's not only literally exporting abroad. This is why the intent element is actually very important. If Cody intended to send this to a foreign entity so they can make an entire army with plastic guns that fire 122 caliber bullet, okay, then perhaps it could be, perhaps it'd be a different story. But the fact of the matter here is you're using a public forum, the internet, the quintessential form. And to preempt another pushback, no, you can't limit this based on IP address, right? You can't have people scan a copy of their passport. This is a strict liability offense. So if you're like Lockheed Martin or Boeing, you have to create a private secured intranet that people with very secure credentials can access. You just create this entire elaborate regime just to share files with a U.S. person who might be somewhere else in the United States. Yes, ma'am.
If the composition of the court changes in the next few years, how do you see the Heller a good precedent, or will it be enough to?
So it's a very good question. The question was, if you didn't hear, with the court changing composition, what about Heller and McDonald? So I'll give you an anecdote. So during Justice Sotomayor's confirmation hearing in the summer of 2009, she was asked, is Heller settled law? And Senator Leahy asked, is it settled law? She said, yes, it's settled law. Not even a year later, she joined the opinion of McDonald, which basically challenged Heller. Now, in Sotomayor's defense, McDonald involved incorporation, which is technically a different issue. But she joined part of Breyer's opinion that said the Second Amendment is a collective right, it's not an individual right. So representations at confirmation hearings are a waste of time. I have another article with Randy Barnett in the Chicago Law Review coming out about this. Their answers are all full of it. They're saying whatever it takes to get through, but that's a different story. So will the court overturn Heller? I don't think they need to. All they need to do is say Heller only protects keeping a gun at home, handgun at home, nothing else. Because at the time, only 2 places in the country actually banned handgun possession, D.C. and Chicago. If they limit Heller to those facts, then it's basically a dead letter. They'll say that doesn't go that far. The word bear has no meaning, right? You can read the word bear of the Second Amendment. So they don't need to overturn it because they're afraid, look, if we overturn it, it'll be like a massive backlash, like a row or something, right? Just leave it there in the books, but say it doesn't extend further than a handgun at home. Doesn't go to carry, doesn't go to having an AR-15, doesn't go to whatever kind of draconian background checks, doesn't affect shall issue or may issue. It's only a restriction on carrying keeping a gun at home. And you keep it locked up. That was a decision that Thomas and Scalia dissented on. You have to, if it's at home, it has to be in a locked box at all times. That way only the criminals have access to it, right? Yeah. Yes, sir.
Again, 2 issues. The first one is that I don't think they have to come out with a decision that says it doesn't extend. They just have to not hear a lower court.
Unless the lower court strikes it down. That'd be the only circumstance. If a lower court strikes it down, they have to take it, which is why our case may be interesting.
Yeah. The second is
yeah.
as far as most of these issues go, I just, the one big issue that still kind of remains out there for me, and I may not have simply read the decisions carefully enough, is the scrutiny that the Supreme Court wants to give the second. Because, do we have an intermediate scrutiny? Do we have strict scrutiny? That, I think, is the major question as to how they're going to sit there and enforce that law. Because until they answer that question, they have, I believe, definitively, then you really got every appellate jurisdiction in the state can everywhere in this country can pretty much decide how they want to deal with it.
I'll tell you, strict scrutiny ain't what it used to be.
Well,
And I'm saying this, we can talk about other cases, but we had an affirmative action case this year, Fisher versus University of Texas at Austin. The court purported to apply strict scrutiny, but they upheld it with basically nothing concrete the university could justify a form of racial discrimination. And then you have the whole women's health versus Heller said, right? Abortion was supposed to be under undue burden standard. That looked an awful lot like strict scrutiny to me, saying that even the government's rationales are not accurate. So I'm not too concerned about scrutiny for the Second Amendment. I think it makes no difference if it's strict or intermediate. What matters, and as I've written about elsewhere, is the burden. Who has the burden? If you're a civil rights litigant, the number one question you want to know is who has the burden. If I have the burden to disprove the government's rationale, I'm going to lose. If the government has a burden to defend their law, they're probably going to lose. And in every single case, the court has placed the burden, that's the lower courts have placed the burden on the individual. In fact, there was one opinion from Judge Easterbrook on the Seventh Circuit where he even said, the government's evidence is not good enough, so I'll put some additional ones, right? Why we need this gun law? He actually did his homework. You know, he put some internet stuff in there, right? When this sort of burden which you can't beat is placed on the individual, that the court can supplement the record, the Second Amendment doesn't mean much. And the court has shown no interest in fixing it. With Nino on the bench, so now we're down to 8, I don't think we'll take it away. I mean, I make this point elsewhere, but the Second Amendment litigants should seriously consider keep away. Right? The same way that unions have tried to keep cases away from the Supreme Court for the last 20 years. Now, like, yes, let's go for it. Let's get a right to collective bargaining, right? Second Amendment lawyers need to think seriously about certiorari. And even our case, you know, it's a litigation decision, but putting that up on a Second Amendment issue could be, well, no pun intended, dangerous. Anything else? With that, thank you very much. Hope it was worth the wait.